Now let us discuss non-international armed conflict. So what are non-international armed conflicts? Generally, as defined, they are protracted armed confrontations occurring between governmental armed forces and the forces of one or more armed groups, or between such groups arising on the territory of a state. The armed confrontation must reach a minimum level of intensity, and the parties involved in the conflict must show a minimum of organization. So the armed conflicts, in that sense, are restricted to the territory of a single state, involving either regular armed forces, fighting groups of armed dissidents, or armed groups fighting each other. But the hostilities or the conflicts in that sense must reach a minimum level of intensity for it to be considered as an armed conflict. So we have here an example of a non-international armed conflict. So we have the conflicts in Syria. So this involves the Syrian government against several rebel groups such as the Syrian National Army, Hayat Tahrir al-Sham, the Islamic State Group, the Syrian Democratic Forces, and other smaller armed rebels. Now let us discuss the applicability of international law, and for this matter, international humanitarian law, to non-international armed conflicts. Traditionally, international law on armed conflicts does not apply to internal conflicts such as civil war or rebellions. In 1949, however, it was decided that minimum humanitarian protection should also be promulgated to cover internal conflict. For this reason, each of the four Geneva Conventions contains a common Article 3, which says, in the case of armed conflict not of an international character occurring in the territory of one of the high contracting parties, each party to the conflict shall be bound to apply as a minimum the following provisions. Number one, persons taking no active part in the hostilities, including members of the armed forces who have laid down their arms, and those placed hors de combat by sickness, wounds, detention, or any other cause, shall in all circumstances be treated humanely without any adverse distinction founded on race, color, religion, or faith, sex, birth, or wealth, or any other similar criteria. This provision pertains to those who are not engaging or participating directly to the hostility or to the armed conflict. So they have the protection of this convention. To this end, the following acts are and shall remain prohibited at any time and in any place whatsoever with respect to the above mentioned persons. So these are the prohibited acts. Violence to life and person, in particular murder of all kinds, mutilation, cruel treatment, and torture. Taking of hostages, outrages upon personal dignity, in particular humiliating and degrading treatment, the passing of sentences and the carrying out of executions without previous judgment, pronounced by a regularly constituted court, forwarding all the judicial guarantees which are recognized as indispensable by civilized peoples. Number two, the wounded and sick shall be collected and cared for. So this simply pertains to those who are wounded and sick, so they are protected under this convention. So the first provision pertains to those who are not engaging or participating directly to the hostilities or to the armed conflict, and the second provision pertains to the protection of the wounded and sick. Unimpartial humanitarian bodies such as the International Committee of the Red Cross or the ICRC may offer its services to the parties to the conflict. So this pertains to the mandate of the International Committee of the Red Cross. The parties to the conflict should further endeavor to bring into force by means of special agreements all or part of the other provisions of the present convention. The application of the preceding provision shall not affect the legal status of the parties to the conflict. The last sentence means that the application does not convert the conflict into an international one and therefore does not preclude the possibility that any participant in the conflict may be prosecuted for treason. Now let us discuss the applicability of the 1977 Geneva Protocol 2. So this is the additional Protocol 2 to the 1949 Geneva Conventions. This first and only international agreement exclusively regulating the conduct of parties in a non-international armed conflict is the 1977 Protocol 2 to the 1949 Geneva Conventions. It develops and supplements Article 3 common to the Geneva Conventions of August 12, 1949, without modifying its existing conditions or application. A non-international armed conflict covered by this expanded guarantee is defined in Article 1. So we have here Article 1 of the Additional Protocol 2. So they are armed conflicts which take place in the territory of a high contracting party between its armed forces and dissident armed forces or other organized armed groups which, under responsible command, exercise such control over a part of its territory as to enable them to carry out sustained and concerted military operations and to implement this protocol. So, as what we have discussed earlier, it involves a high contracting party against dissident armed forces within the territory of that single state or high contracting party. Article 1 further adds that the protocol shall not apply to situations of internal disturbances and tensions, such as riots, isolated and sporadic acts of violence, and other acts of a similar nature, as not being armed conflicts. This is true even if the armed forces of the territory may have been called upon to suppress the disorder. So these are instances that are not considered as armed conflicts. So these are internal disturbances. So we have tensions, riots, isolated and sporadic acts of violence. So these are not considered as armed conflict. It will thus be seen that Protocol 2 sets down requirements for what it calls material field of application. So there are requirements for a conflict to be considered as an armed conflict. First, the armed dissidents must be under responsible command. So there must be an organized armed group and they are under a responsible command. Second, they must exercise such control over a part of its territory as to enable them to carry out sustained and concerted military operations and to implement this protocol. So this pertain to their control over a particular territory in that territory of a single high contracting party or state or a country. The protocol thus sets a very high threshold for applicability, higher than the threshold for the applicability of Protocol 1, which does not require control over territory. For this reason, in the conflict between the Philippine government and the National Democratic Front, the Philippine government has been able to maintain consistently that the NDF and its New People's Army have not crossed this threshold, and that therefore what applies to them is common Article 3. So in the case the Philippines, the Philippine government and the National Democratic Front, the New People's Army, the conflict between them is not covered by the additional Protocol 2, but the conflict or the armed conflict is still covered by the common Article 3 of the Geneva Conventions. So that's our discussion for non-international armed conflict.